Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today we have another former guest, actually, but in the dark ages before we kind of got onto YouTube and Zoom and everything here. He is a criminal lawyer and very successful at what he does, and certainly going to talk about right from the beginning, from an arrest all the way through till trial and potentially an appeal there with Hussein Ali today. So thanks, Hussein, for joining us today.
Thanks for having me.
So maybe you can give us a little background. I know you've been singularly pretty much focused on criminal law perhaps throughout your entire career here, but maybe tell us a bit about getting into law school there at Osgood and certainly getting into criminal law afterwards.
So I went to U of T Scarborough. From there, I went to Osgood, same time as you, John, and then got into criminal law. I had a bit of a naive understanding, of what criminal law was, and I felt like I would just learn criminal law and do it on the side and help someone if they got in trouble, thinking you can kind of do it that way. But I got a summer job at what was then Pinkowski's, and that led to an articling job, and I've been with the what that firm turned into since.
And I guess you probably get this question all the time. So what's it like being a criminal lawyer? What's like I know each day is not really typical, but what are some of the things that you deal with just on a week by week basis or a month by month basis?
I would describe it as hot and cold. The down parts, a client gets convicted, a client you think's innocent gets convicted, someone goes to jail, someone separated from their family. That obviously that's hard, right? But it feels great to win. Feels great when you get somebody acquitted who you felt was innocent. Feels great to win a case that you thought you had a low chance of winning. So there's highs and there are lows. You just try to create a mental space for yourself where you can deal with both, and you try to stay in the middle.
Perfect. So let's kind of maybe start something simple here. I mean, for my paralegal students, this is a big thing for them, not so much obviously for us, but what are the different sort of classifications there of offenses, and how does that kind of start the criminal process in terms of whether you get charged on a hybrid offense, if it's straight summarily, or a straight indictment?
So they've recently hybridized the criminal code. Well, what that means is they've given the Crown elections to either proceed summarily or by indictment on many different offenses. But the Crown has a choice on most offenses to proceed summarily or by indictment. If they proceed summarily, what that means is, so the U.S. equivalent would be a felonies and misdemeanors. So a summary offense. If the Crown elects to proceed summarily, that means the trial will take place in the Ontario Court of Justice, not the Superior Court of Justice, and it means that the trial will be held or adjudicated by a judge alone, not a jury. So Crowns have offenses most all offenses. The Ontario Court of Justice deals with almost all criminal prosecutions, or a huge percentage of them. So what typically goes to Superior Court? You'll talk any sexual assaults that are more serious in nature, they go to Superior Court. Murders, any kind of homicide, firearms, drugs, those are the type of offenses that you see in Superior Court. Most other offenses stay in provincial court, the Ontario Court of Justice. So if the Crown's proceeding summarily on a case, the trial happens in the Ontario Court of Justice. If the Crown proceeds by indictment, that triggers an election for the accused. So the accused now gets to decide, do they want their trial to happen in the Ontario Court of Justice or the Superior Court of Justice? That's the first decision. The second decision is, do they want their judge to be a jury or a judge alone? So if the Crown proceeds by indictment on you, you do have that election. On some offenses like murder, you have to have a jury trial. But for most other offenses, it's your choice. Do you want a jury trial? Do you want a judge in Superior Court? Or do you want to, just because they're proceeding by indictment, you're still allowed to have a trial in provincial court if that's what you want?
Now, we'll certainly circle back there because, I think a lot of people want to know what goes into the decision to go with one route there or the other. But let's kind of back it up to right when a client calls you and they say, Hussein, I just got arrested. I'm in 42 division in Toronto. What's that call like? And certainly what's the process there? I mean, in terms of your rights there and what the police can do in terms of either holding the person over the next day for bail or releasing them with or without some conditions.
All right. So regarding your release, the state, the police have to bring you before a justice of the peace within 24 hours, or they have the option to release you from the police station on a promise to appear, which is a promise to come to court on a particular day. It also includes a particular time for you to provide your fingerprints. Sometimes they take it on the day that you're arrested, or they can release you to an undertaking to an officer in charge. They're both forms of bail. So a promise to appear or an undertaking are both forms of bail. They both result in you being released from the station on the day of your arrest, or even from the side of the road, depending on more minor charges where they don't even take you to the station. For more serious things or situations where individuals may have already been on bail or have criminal records, those are type of factors that go into the decision as to whether or not to release you from the station or to hold you for bail. If they do hold you for bail, you have to be brought within 24 hours, usually the next day, in bail court. And at that point, the Crown either says, you show cause, or will try to show cause as to why you should remain in jail, or the Crown can consent to your release.
Now, if you do get someone calling you saying, Hussein, look, I'm here, I'm in charge with theft under 5,000. They're going to hold me for bail. What's that conversation like? I mean, what are you doing in terms of preparing them and potentially some sureties then the next morning for a bail hearing?
So the main objective that you want to get to the client during an arrest call is you want to explain their right to silence to them. You want to make it clear to them that they do not have to make a statement to the police. They do not have to answer any of the questions posed by the police, and that it's their right to remain silent, and that no negative consequences can flow to them if they do remain silent. So that's the main objective when you take an arrest call. You also have to get, obviously, information for sureties. You want to get contact information for their family because you may not be able to speak with them again. And you want to explain to them that they'll be held for bail if you know that information, and that they'll have a bail hearing the very next day. But the main thing is to get the contact information, and also to make sure that they understand their right to silence. I also go a bit further most of the time, and I try to identify whether or not there's any evidence that may be out there in terms of witnesses or videos that I need to get working on. And I may ask them some questions about where the stop happened or where the interaction happened with the police, just to figure out if I need to go there or send somebody there to try to see if there's evidence that can help me.
Now, one of the things, obviously, over the last year and a bit, the bail process has been a little different than bringing them back to the courthouse and having the bail hearings. How have you found, I don't know if you've done many bail hearings virtually, how have you found that process compared to what it was before?
So you chipped out there for a bit. You're asking about the bail process during COVID?
Yeah, in terms of, how have you found the bail process in COVID versus pre-pandemic?
Honestly, I think it's improved. Before you'd get an arrest call, that would mean you would have to go to the particular courthouse. You'd have to hang around the entire day sometimes and not get reached. There was a lot of waiting around. There was a lot of juggling. Now it's improved because everything's done through Zoom. There's bail vetters who you interact with to discuss releases beforehand, and everything's ready to go. So you can be there from the night before, you prepare surety declarations, you get the email contact of the Crown who's making the decision of either we're having a hearing or it's going to be a release. You email them the proposal, you ask them to consider it. They tell you, no, we have to have a bail hearing on this, so you're ready to go. And you just wait for your email to say, okay, we're ready for you now. So in that respect, it's much improved from my perspective because there's other things that I can do during that time as I wait for my bail hearing. And my sureties don't have to drive downtown, for example, or wait around all day. And sometimes they can even work until the hearing's about to start. So it's vastly improved, in my opinion.
Now, in terms of just the actual, if it does go to a hearing, if the Crown is opposing, what are sort of the reasons they would oppose someone from being released? Again, certainly mindful of the fact, obviously, that at that point you're innocent. Or, I mean, pretty much throughout the whole process, you're innocent until proven guilty. What can they hold someone in custody for in advance of their trial?
So there's a right to reasonable bail. So you have a right to reasonable bail under the Charter of Rights and Freedoms. Now, depending on what you're charged with, depending on whether or not you were on bail at the time, you could be in a reverse onus situation. A reverse onus means that you have to show why you should be released. But most of the time, it's the Crown that has to show why you shouldn't be released. And if they haven't shown that, you are to be released. The reasons that the Crown can say that an accused should remain in custody are one, that they may commit other criminal offenses while on bail or interfere with the administration of justice or a justice participant. So that just means that the Crown will argue that if we release this person, they will commit another criminal offense, or they will possibly try to intimidate witnesses or other people who are involved in the case. That's called the secondary ground. So that's the main battleground where most of the time there's a fight about whether or not someone should get bail. The factors that people consider are the seriousness of the allegations and the individual's track record for compliance with bail and the individual's criminal record. So, and the strength of the case against them. So that's a secondary ground that's almost always engaged when the Crown is arguing that someone should stay in custody. The primary grounds have to do with whether or not you'll appear in court. So that has to do with whether or not we need to keep you in jail to make sure that you answer to these charges. That's rarely an issue. In most cases, people have ties to the jurisdiction, their families in the jurisdiction. So, courts aren't concerned that you're going to flee. But obviously, the more serious the charge, those factors may be engaged, but it's rare to be detained on the primary grounds. So the primary grounds has to do to whether or not you'll go to court. Secondary grounds has to do whether or not you'll commit offenses if released on bail or interfere with the administration of justice. And the tertiary grounds used to be reserved, used to be used sparingly. It's now used all the time. And that's basically a policy ground. And then what the question is, if we were to release this individual, would a reasonable member of the public lose faith in the bail system if this person were released? And the factors to consider there's 4 factors in the criminal code, the seriousness of the allegations, whether or not a firearm was used, whether or not you're looking at a lengthy term of imprisonment. It's not an exhaustive list of factors, but it has to do with any factor that anyone can really come up with in their mind can be argued on the tertiary grounds. And the Crown will argue, if you release this person, given the strength of the case, given how much time they're going to spend in jail, given the fact that a firearm was used, nobody will respect the bail system and people will lose faith in the administration of justice. So those are the 3 bases upon which bail can be denied: primary, secondary, and tertiary grounds.
Now, certainly, what can you do then as counsel to kind of deal with, I mean, maybe not so much the primary ground, because you're seeing more so you're seeing the secondary and tertiary ground, but you can address that as well. But in terms of, hey, my client is being held and the Crown is seeking their detention on the secondary ground, what are the things that you can do perhaps to convince a judge or even maybe convince the Crown that this is not needed? What can you do on behalf of your client?
Well, the 2 things that your job as counsel is to make sure that the bail plan is solid and responsive to the seriousness of the allegations. The more serious the allegations, the more supervision your bail has to have. So for the most serious of offenses, you're going to want to ideally have a bail plan where your accused is monitored 24/7 by a responsible surety. So it's your job to design a bail plan that's responsive to the allegations. And it's also counsel's job to prepare their sureties to testify. So you prepare a surety to testify by explaining to them their duties and obligations, explaining to them that they're a jailer in the community. It's their job to make sure the accused attends court. It's their job to make sure that the accused follows the conditions of the bail. And if the accused doesn't follow the conditions of the bail, that you're to call the police. So courts want to see responsible sureties who understand their obligations, who are no nonsense. So it's counsel's job to prepare a plan that is responsive to the allegations, prepare the sureties to testify. And the other thing that counsel can do that goes a long way to getting your client bail is to show that there are problems with the Crown's case. Because realistically, if you can show a court, I'm going to win this, I'm going to win this case for this accused, they're far less likely to deny them bail, because the court's going to know that if I deny this individual bail, he or she may spend a year, 2 years in jail for an offense he'll never be convicted of. So it's counsel's job at a bail hearing to demonstrate or try to show a court that there's triable issues here, that we have a good chance of success here, and that the case isn't overwhelming. In my opinion, those are the two factors that will go that really dictate whether or not someone is given bail on serious charges.
I agree, and thanks for sharing all that. I think certainly we've seen a lot of changes there with COVID, right? And people are, and as you mentioned, certainly it's a lot of differences there in terms of how it's working. And I mean, I think a big plus there is you don't have to have the sureties go down and spend like perhaps the entire day at Old City Hall waiting for the matter to be called, and then it may not even be called, right? So you think these are some of the some of these changes should definitely be sticking around going forward for the bail process, or is there anything maybe you can tweak a little bit once we return back from sort of the pandemic with the vaccinations going up?
I would suspect that bail court as we knew it is dead. I think that this is the way to go. There are just so many advantages to it. It assists everybody who's part of the bail process. I don't see anybody who's part of it who doesn't like the current system. And it also allows for bail hearings to be addressed that were missed before, because now if you had 5 contested hearings, there's only one justice of the peace, or there's only enough judges assisting, people wouldn't get reached. I've had situations where I would go 2 to 3 times, 2 or 3 days in a row and not get reached. Where that would happen, the new Zoom technology, your justice of the peace can be in Newmarket, they can be in anywhere, in Peterborough, Lindsay, for an Old City Hall case, and we could set it up so there's always enough justices available to hear everyone's bail hearing relatively quickly.
Now, moving on after the bail process, and let's say for our hypothetical here, your client is released. What's the next steps in terms of preparing for the matter? And certainly I have a lot of students that come into criminal law and they've watched like How to Get Away with Murder or Suits or something, and they're like, oh, so like later that week you're going to have the trial, right? I mean, maybe you can kind of explain the process from once they're released, or even if they're held, until getting towards trial.
So once someone's released, you typically want to speak with them early. You want to get retained, and you want to start. My main thing is I want to make sure there's no evidence out there that I need to get. Like I said before, I want to make sure, is there a videotape that I need to subpoena? Is there a witness that I need to speak to quickly? Because if you don't speak to witnesses in a timely fashion, there's going to be an argument that how could you remember this? If you're speaking to a witness a year and a half later and they haven't written it down, that they're liable to attack. You're better off if someone's given you a statement early on when everything was fresh in their minds, or they really might not remember particular details that you need them to remember a year later. So I want to track down witnesses. I want to get any videos. What I also start doing at the very beginning is I ask everybody for a biography about themselves. Tell me about your family. Tell me about how you grew up. Tell me about any emotional, physical, mental, sexual abuse that you endured, any mental health issues. I want to know everything about you. So when I speak with the Crown, I have that background ready. I also ask them for a resume, because after you're released, the first step is to get the disclosure. And then the second step after getting the disclosure is you have a Crown pretrial, which is a discussion with the Crown about the case. And that's where you kind of feel out where the case is going, and you feel out how the Crown views the case.
So let's look at disclosure there, and certainly what kind of, maybe you can share some advice there for, I know I have at least one student here who was actually a disclosure clerk for a colleague of ours. And what do you look for in the disclosure, and kind of how do you go from the initial disclosure to additional things that you're looking for and asking the Crown?
So typically you're gonna get the disclosure, you're gonna review it. Once you review it, you're gonna know all the officers that are involved. So you're going to want to make sure, do I have all the officer notes? Once you know you have all the officer's notes, you want to ask, did any of these police vehicles have video cameras? Then you're going to want to request the video camera. If you know property is, if you know, for example, they've done a cell phone analysis, and that's out there, you want to ask for that. If it's a wiretap case, you want to ask for the wiretap. So it's really kind of case specific. The courts are pretty good at getting you disclosure now, but there are sometimes things that slip through the cracks. You want to make sure also you have all the witness statements, not just the summaries, but the actual videos or audios or both, of any witness statement. So you want to make sure you have everything that the police have in their possession, and you want to request those things.
Now we were just talking about COVID and how things have gone differently. Here's probably another big change. I think certainly, I'm sure you can do a lot more today with set dates and how that process works. So maybe you can share a bit about what's different now than it was pre-pandemic in terms of dealing with that disclosure and making requests for additional disclosure and leading up to the Crown pretrial or judicial pretrial as it may be.
Yeah, so about the time when CDs became obsolete, criminal law started using CDs. So disclosure used to be provided on a CD, and you'd have to go pick it up, and you'd end up with all these CDs with disclosure on it. Because of COVID, we didn't want people coming to the courthouse, so what they developed was Disclosure Hub, where everything is just provided to you on your hub. You can download it as a PDF. It's all in one place. You can organize it by courthouse. You can organize it by client names, and it's easy to access for you. So that's been a wonderful development in terms of disclosure. There's also been centralized email addresses where you send all your disclosure requests to, and you get prompt responses now to all of these requests. You can also ask them who's assigned to the file. They'll tell you this Crown's assigned, and you can email the Crown directly on the case to see about when you're going to get this disclosure, or if some disclosure exists. So the disclosure process post-COVID has been greatly improved.
Now, let's say you have all that disclosure, you've reviewed it, you've sent a couple of more requests, you've gotten everything you need. So you mentioned the Crown pretrial. What's the Crown pretrial like, and certainly how has that been going? I assume you don't have to go into the courthouse now and talk to the duty Crown as you may have had to when you were appearing in person. And what about just the appearances themselves when you have to address those matters?
Yeah, so in terms of set dates, if you're talking about that, so once you're released from the station, you're given a court date, and then there will always be a next court date until your case is dealt with. So set dates are what is a term used to talk about all these court dates in between being charged and the eventual last day of trial. So set dates are also greatly improved. There's no more set date court. It's all done by Zoom. It's pretty organized. They're tinkering with it to make it better in terms of making sure people don't wait too long to be admitted to the court. But that saves counsel money. That saves paralegals money. It makes it easier to attend multiple courthouses. And it's also much easier on accused individuals who used to have to come to court and wait in the hallway the entire day to get their matter called. So all of that is done with, and set date court. I can 100% say set date court as we know it is dead, and it will be through soon going forward. In terms of the Crown pretrial, that's a discussion with the Crown, and you're going to know as experienced counsel the Crown that you're dealing with, whether or not they're reasonable, how reasonable they are. You're going to be able to have your compass is going to be calibrated. You're going to know which cases, some cases, the Crown has to proceed with. There's some cases that the Crown obviously shouldn't be proceeding with, and then there's cases in the middle. So what you want to do for the Crown pretrial is you want to be able to advocate to the Crown why they should not prosecute your client. You provide that resume, provide that bio, maybe you provide some background in terms of why the offenses happened and what you're doing to make sure that they don't happen again, and why it isn't in the public interest to prosecute this person. So those factors may be they may lose their job. The complainant may not want them to proceed. They may have gone through a traumatic incident at the time. They may be in school, and it would be a shame to render them unemployable. So you want to present all those facts to the Crown attorney. Ideally, what you want to do is you want to email them the day before with a package so they have time to read it, or even a week before, So they have all that information before them, so they can take a look at it and say, you know what, I've reviewed everything you've told me. I'm willing to peace bond this, or I'm willing to withdraw this if they do a certain amount of community service or provide a charitable donation. So that's the goal of the Crown pretrial. For the cases that aren't going to be withdrawn, you typically want to know, are you proceeding by indictment? Are you proceeding summarily? And then, is it an offense that you get a preliminary inquiry on? And if so, let's set a judicial pretrial, which would be the next step after the Crown pretrial.
So, in terms of at that stage there now, you mentioned certainly some things could be withdrawn or go through diversion. What are some of the things? I know you mentioned obviously showing the resume and the bio and what they're willing to do, depending obviously on the offense. If it's something where you may need to make a donation or do some community service or like a driver's program. But what are some other ways in terms of pushing for that diversion as opposed to going through, and maybe you can also address, you mentioned peace bond there, what a peace bond is and how that impacts your clients.
So, one of the ways to get it is be persistent, be clear, like back up what you're saying. Like anyone can write an email saying, this person suffered through trauma, this person had deaths in their family. That's different than providing them the articles where they had family members die, or provide evidence that someone was charged for some form of abuse. So if you want to say something, you want to back it up. So you want as much proof as you can, because talk is cheap. That's my motto. Talk is cheap. So back up what you're saying. Back up what you're saying at all times. Now, you asked what a peace bond is. So peace bonds, for example, there's a fight between two individuals, or there's a domestic assault. A peace bond is a recognizance. So it's the same as a bail. It's a promise that you make to a court to keep the peace and follow certain conditions. If you breach the peace bond, you can be charged criminally. So peace bonds in the domestic context, for example, what you'll see a lot is there'll be a domestic assault. If the complainant is uncooperative, or if there's no history of abuse and the assault is minor, we'll get the accused to do a program, usually one called PARS, which is a partner assault program, or some equivalent. They'll get counseling. It's essentially counseling. And once they're done their counseling, if they have a positive report, the Crown will withdraw the criminal charge, and the accused will enter into a peace bond where they're promising to keep the peace in relation to the complainant, to have no weapons, and to follow any other conditions. Those conditions may include not to come within a certain distance of an individual, or to only communicate with them as long as they're consenting to have communication. Meaning, we'll let you go see your girlfriend or your wife again, but if she says to you, I don't want to see you, you have to leave. So typically those peace bonds last for 6 to 12 months. I'd say 12 months is the most common. And that's how we resolve minor domestics where the complainant may not want to proceed, and also minor fights between individuals. And even sometimes for serious cases that may have major deficiencies, as an added layer of protection, you put in a peace bond. Those typically will order an accused not to have any contact. If you have two guys who got in a big street brawl, you're not going to have an exception to let them communicate at all because they don't have a relationship. So those type of bonds will be used to say, if you see this person, you can't be within 500 meters of them, 200 meters of them, something along those lines. They're also used, like for Newmarket, for example, has gotten creative, and they started using them even in shoplifting cases where you put somebody on a peace bond and say, you can't go to this mall or you can't go to this store. So it's a way to keep you on a court order, to hold you accountable for a bit of time, and to make sure there's peace.
Now, you mentioned the judicial pretrial that will sometimes follow the Crown pretrial if it's going, depending on the direction it's going. Maybe you can discuss now kind of how have those been conducted in the pandemic, and what are you hoping to accomplish if it's something that could be resolved versus if it's something that's going to go down to trial.
So they're being conducted usually by phone as well. The Crown pretrial is by phone. Some judges want to do it by Zoom. Either one really works. Nobody really cares. So they're done that way. So when you get to a judicial pretrial, it's another opportunity where you can maybe advocate for the Crown not to prosecute your client. The judges, depending on the judge, some will weigh in heavily, some will not. So some may pressure the Crown and say, I agree with the defense. Maybe you shouldn't prosecute this, or maybe we should peace bond this, or maybe we should do something else here. If that's not happening, what you're doing at the judicial pretrial is a time estimate. Basically, it's an estimate for how long the preliminary inquiry or the trial is going to take. You talk about the witnesses, you talk about the evidence. The judge asks you, are there any motions, anything special about this case? How many police witnesses, how many civilians? How long do you think it's going to take? And then the parties estimate a length of time for a trial or a preliminary inquiry. Now, if you want to resolve a case, a judicial pretrial is also an opportunity for you to tell the judge some things about your client, how you want to resolve, and you can tell the judge, this is the type of sentence I'm looking for. Now, some judges are more forward in terms of telling you what they will do than others, but usually a lot of the judges that they have conducted the judicial pretrials are good fixers, and they let you know that sounds reasonable. If what you've told me is the situation, I would give your client the sentence that you're seeking. I don't think it's going to be a problem, right? So usually the Crown doesn't have a problem with that. Sometimes they do. Usually the Crown, they're fine with the case going away, and the sentence is whatever the judge wants it to be. But that's what you're trying to accomplish at a judicial pretrial. One of those objectives.
All right, so let's go down with that route then. So let's say you have something that your client will be agreeable to. The Crown seems to be on board. The judge may seem to be on board, or indicating that they would likely support that if that's the evidence there. What's sort of the next step there in terms of communication with your client about a potential resolution?
Well, typically, you probably already had that discussion with your client beforehand. You probably understand the parameters of where their head's at. You've probably told them that it's going to either be this or that, and then you speak to them afterwards and you say, I've spoken to the judge. This is what they've told me. Or you may even reach an agreement with the prosecutor, right? So one thing I should have mentioned is sometimes you and the prosecutor may already have concluded that this is an appropriate sentence, and you just want to make sure that the judge is okay with it. And if the judge usually will tell you, that's fine, I'm okay with that sentence, you guys have decided it, I will give that sentence. That's called a joint submission, right? So after the judicial pretrial, you sit down, you get your instructions in writing from your client, you explain to them the pros and the cons, and before you do the guilty plea, you have to do the guilty plea inquiry with them, which means you have to ensure that they understand they're giving up their right to a trial, that at the trial, the Crown has the burden of proof, that the sentence, even though is whatever the judge decides it's going to be, and you got to make sure that they're entering the plea voluntarily, meaning that they're not being pressured to do something they don't want to do. And you also have to discuss any collateral consequences of a guilty plea. Those are things like immigration consequences, any driving type of prohibitions, and even travel to the United States, for example.
All right, now we can go back to sort of the other direction. There is, let's say it's not something that's going to be resolved after the judicial pretrial, and you're going to set it down for trial, and perhaps there is a charter argument that you're going to, or another pretrial application that you're going to bring. Can maybe touch on one or two maybe examples of what you could be bringing prior to the trial, and why would you be bringing, let's say maybe like a third-party records application, for example?
Yeah, so if you're doing a trial estimate, there are a number of applications. We won't be able to list all of them, but charter applications are let's start with the most common. So there are different kinds of charter applications. There's what's called an 11B application, which is an application to stay the charges based on unreasonable delay. You can have a charter application for violation of rights to counsel. Usually those are section 10B and relatedly section 10A. You can also have applications to exclude evidence based on not only 10A and 10B, but section 8 and 9, which are unreasonable search and seizure and arbitrary detention. So those are the main types of charter applications you can bring. There's also other applications like disclosure motions. If the Crown, for example, is resisting giving you something, you can bring a motion to have the judge compel them to produce it. Like you mentioned, John, you could have a third-party records application, which is basically when a document's in possession of a third party and not the state and isn't considered first-party disclosure, you bring in applications subpoenaing those documents to court and you argue to the judge why it's relevant and why you need it for your defense, and the judge can compel that third party to produce that document. So those are some of the common applications that you see from the defense. And the Crown also has applications that they can attempt to bring in circumstances where they're required to file because something may be presumptively inadmissible at a
trial. Okay, and now let's say that we arrive, it's the trial, right? It's been scheduled down. I do actually have students who have over the next day, today and tomorrow, they're doing mock trials out of a shoplifting case, incidentally enough. So I know we can obviously have a whole hour discussion on trial preparation and running a trial, but maybe you can sort of, from your experience from where you started to where you are today, I mean, what are some of the kind of common mistakes you've seen with young lawyers and young paralegals or relatively new to the profession, and what kind of you've learned from your experience of the do's and don'ts of running a trial?
I think that one of the common mistakes you may see is that you just don't know your case well enough. You really have to know your case. You have to know everything about your case. That includes everything your client has to say. You have to know everything that everyone says in the case, and you have to have spent enough time thinking about it to understand how it all fits together. So one of the common mistakes is counsel won't appreciate the significance of a piece of evidence and how that makes their client appear more guilty, or how it creates an additional problem for their defense. So really knowing your case and understanding how it all comes together is critical, because we're in an era now where there's so much digital evidence and so many inferences can be drawn based on, when you piece all these things together, they form a picture. And you really have to be able to see the picture, because the Crown doesn't have to tell you the picture. The Crown just has to give you the individual pieces of the puzzle, and you got to put it together and see what picture it paints. And if you miss that, you're going to make critical mistakes in terms of, how you steer the direction of this case. You have to know how these things fit together well in advance, and you got to know your defense. Another common problem is I see people, deciding to call their clients and beginning preparations, after the Crown's case is closed. Like, they've done no preparation to prepare their client. That simply isn't going to work. If you're going to call your client, you have to prepare them weeks and weeks before the trial. That also helps you understand, while you're conducting a case, what evidence helps you, what evidence hurts you, and how you can undermine or change that evidence to support your own theory, and the suggestions that you have to make to the witnesses in the case about what really happened. So those are common mistakes. And related to that is, you see a lot of people running theories or defenses that are just simply not believable. They're too different. Usually the truth is, a shade or two different than what the complainant is saying. It's usually not something completely off the wall. So sometimes you see people running some really crazy, unbelievable theories that just don't jive with common sense.
Now, circling back to what we were talking about at the start there of the different types of offenses, and you may have an election. Perhaps, I mean, is there a reason why you'd be going with a judge alone versus a jury, or what kind of factors play into that?
I think every lawyer is different. There are some lawyers who are heavily skewed jury. I would probably be one of the lawyers who has no problem being in front of a jury, and oftentimes I select a jury. So that's usually what dictates it. However, most criminal defense lawyers are more malleable than that, and they're willing to go with either one. And they understand that there are situations where you don't want a jury. Like, for example, if your defense is identification, most of the time, if it's a pure case of unreliable eyewitness identification, you probably want a judge for that, because that's a pretty nuanced area of the law. It's a bit complicated, and judges have been cautioned not to convict on poor identification evidence. That being said, with all the digital evidence that we have now, I think a pure identification case is getting less and less frequent. Another area of law that kind of lends itself usually to a judge alone trial is possession cases, because the law of possession again is pretty cut and dry. The judges know the limits of that, and you can pretty easily predict the outcome depending on your facts. So possession cases, some possession cases, some identification cases, you or I would lean towards judge alone. But that said, I've run possession cases and identification cases in front of juries as well. It really depends on the facts of the case and who
And
your judge is, right? Who your judge is you may know that, right? You may know who your judge is. So during COVID, we've been allowed to select a short list of judges. So who your judge is obviously a major factor.
now, is there anything in terms of tactically how you kind of present the evidence, ask the questions, opening statements when there's a jury versus when there's a judge?
So I think that one of the biggest difference is that when you're in front of a jury, certain rudimentary concepts, you have to make sure that they understand that. You don't have to do that with a judge. A judge understands rudimentary concepts and terms. So you have to be more simplified and a bit slower with a jury just to explain or have witnesses explain what something is and or why something's done and why we do it. And you don't have to do that with a judge. But for both judge or jury, you have to be clear. You have to let them know why this is important if you can. If they can know why it's important and why they're hearing this evidence, they're more likely to retain it and start thinking about it in the way that you want them to think about it. You don't want to just be calling evidence and basically they don't know what you're getting to. It's kind of like the puzzle analogy. You have all these pieces to the puzzle, but you have the box, so you know what the puzzle is supposed to look like. So you want the jury to know or the judge to know, I'm arguing self-defense here. I'm arguing that my client was attacked, for example. You want them to know that from the beginning so they can start thinking and processing the evidence in consideration of what you're going to argue at the end. So I think one of the key points is that when you are presenting evidence, you want it to be clear. You want the jury or the judge to know what your defense is so they can start latching on to certain facts that help that defense.
And after a trial, I mean, obviously, if your client's acquitted, excellent result there. But sometimes they're going to be convicted, and then it proceeds to sentencing. What are some of the sentencing considerations that students should be aware of? And again, one of the other things they're doing is sentencing hearings today. And how do you kind of go into preparing for one, especially if it's you mentioned joint positions, but if the crown is not going to be joined, how do you kind of go and prepare for a sentencing hearing when you're not sure of where this could go, and what are the different things you can ask for?
You want to explain to the judge why this offense happened. You want to explain your client's circumstances. Did they come from harsh circumstances? Did they come from a home that was broken, that had abuse? Were they mentally abused, sexually abused, physically abused? Do they have any mental health issues? Did those mental health issues impact their decision making? Did they go through any other trauma? Have they suffered any significant losses? You want to basically tell their story. You want to explain how they got to this point, and you want to explain, very important, why it's changing going forward and why the offense isn't going to repeat itself. And ideally, you want to be in a position to say, it happened because of all these reasons. The accused is addressed it through counseling, or they're in a new relationship that's more structured, or they've eliminated these negative associations. They now have employment. They now have gone to school. They now have turned their life around. So let's give them a sentence or her a sentence that's going to help them on their course for rehabilitation as much as possible.
And after that, I mean, if your client wants to go in a route of appealing the decision, what kind of goes into that in terms of preparing them, or at least advising them of what the options that they do have and the timelines? And if you do end up doing any appeal, or kind of how is that different than preparing for a trial?
So, once you get the written reasons, if I'm not handling the appeal, if another lawyer is handling the appeal, you hand that over to the appeal lawyer. The appeal lawyer will typically have a discussion with the trial counsel and ask the trial counsel, were there any rulings that you disagree with? Is there anything happened during the trial that you think is an appealable issue? And you discuss that, right? Then you'll sit down with the appeal lawyer. You have 30 days to appeal. You can file the appeal, and then you can move forward with the appeal lawyer, depending on the cost and what the appeal lawyer tells you about the likelihood of success becomes a cost analysis, really. Are you going to pump more money into this? You probably will if you think you can win. You probably won't if you think you're going to lose.
And on the other end, if you were the appeal lawyer, what do you kind of look at before deciding, telling your client, hey, we should go ahead with this?
You're going to look at you're going to look at the reasons, because you're going to get those first. Then you're going to speak to the trial counsel, ask them what happened, and at the end you're going to get the transcript of the trial, and you're going to look through the trial, and you're going to see what rulings were made, and what transpired. If anything arose during the trial that creates an appealable issue, and you're also going to speak to the client about the conduct of the defense, and whether or not everything was done properly at that end of it as well.
Now, and thanks for kind of going through that. I think we've kind of gone right from the beginning here pretty much to the end, and it's like a great review of all the stuff that we've covered, certainly in criminal law. I see a couple of questions here from the students here. Our first one is about going back to the peace bond. They wanted to know kind of how specific are the conditions, or are they kind of vague, or how do you know what would constitute a breach of one of those conditions?
So conditions in law are supposed to be easy to understand and clear. In terms of how specific, they typically say not to communicate so-and-so person, except with their, or written prior written but orally revocable consent. It's a statutory term to have no weapons, and there's no limit to what terms you can put on the peace bond. Whatever counsel agrees should go on the peace bond will go on the peace bond. But typically, you can get creative. You can use that also, the terms, to try to get a peace bond. You could say, well, we can have a peace bond with this condition and that condition, and that'll satisfy your concerns. So you can put any condition on there, but any condition that goes on there will be clear. Most judges really won't let you have a condition on there that's hard to understand, because they understand that causes problems for the accused.
Now, another thing we've talked about quite a bit here is in terms of diversity and mental health within the legal profession in general, and certainly you were addressing it from your client's perspective. What are some of the things that you've done or you found in terms of, especially you're dealing with murder charges, some pretty serious allegations against your clients? Kind of what have you found over the years that you've been able to kind of take a step away and take care of your own time there, while dealing with such heavy substantive matter here?
I mean, how do I deal with my own personal time?
Yeah, with your own person, how do you kind of find a way to balance everything, especially running a practice as well,
Yeah.
and things like that?
I think you really have to understand, and it took me years to realize this. You have to take care of yourself if you want to take care of other people. So you have to plan your vacations. When you go on vacation, don't bring work with you. Like, shut it off. It's hard to do, but you really have to. You can't just be physically away. You have to be mentally away, and you come back recharged and refreshed, and ready to go. Because criminal law is heavy, and there's a lot of emotional baggage that comes with it, and a lot of stress. You really need to disengage from that stress. You need to have your practice in some responsible hands while you're gone. Your phone is forwarded, and you just forget about it for 2, 3 weeks, whatever it is. The other thing too is you got to schedule smart. Try not to ramjack your schedule with back-to-back trials. If you have to do that, look at what the actual trials are that are back-to-back. Are they two really heavy, intense trials? Are they, a really hard trial, then a little simpler trial? Is it a trial that follows one that may resolve? Like, build in some contingencies for yourself. Try to space out your trials. And also on the vacation point, don't schedule a vacation and then you're starting a trial the Monday after the Friday or the Saturday when you land. What you're coming back to will ruin your vacation. So you almost need to go away and then have another week where you're not doing anything. And then you can do some admin or whatever and catch up on your emails, but nothing that's going to ruin your holiday. Like, you have to step away. You have to take care of yourself. You have to take care of your family. Otherwise, you're just going to get burnt out.
And certainly there, I think some great advice there. I think burnout is something, especially in the legal profession. We feel that we can take on all of these cases, and we maybe have attachments to some of our clients and want to kind of take that on, and then we don't realize that we've got to take care of ourselves too. And thanks for sharing that. I think certainly having COVID probably changes a little bit of your vacation plans, but I mean, even if that means sitting at home for a few days and not connecting with everything, maybe that's also needed. So, Hussein, thank you so much. As always, it's always great to talk to you, for sharing all of that, and especially going kind of from beginning to end there, and a little bit there at the end. So, wondering if you have any final words of wisdom, anything that maybe we didn't touch upon, from all your experience. Now, if you look back to where you were at, at Osgood, and certainly, I always hold a special place in my heart for you for when getting me after the the events there. Was always great that Hussein would still be around on campus, so I can get home, get a ride there. So I do definitely gotta take you out somewhere in Durham one of these days. But any final words of wisdom? Always appreciate speaking with you.
Just, in your practice, try to excel, right? Try to know the law better than everybody. Keep up to date on the law. Read whatever you can read, and try to stick out. You'll find that it's not that difficult to stick out in your career field. So just outwork people. Be competent in what you do. If you're competent in what you do, your business will grow. You won't burn bridges. You won't be getting a connect for work and then screwing it up and then ruining that connect forever. Just become good at what you do, and don't be afraid to learn it at your own pace. Don't feel like if you feel a case is over your head at the beginning, then bring somebody else on. Bringing somebody else on to do the case, you win the case, and now that source of work is happy with you, right? So always, learn things at your own pace. Understand when you're over your head, and get a mentor. You have to have a mentor who is more seasoned than you, who can guide you, and speak to as many people as you can about your cases, because you'll get different ideas that help you understand, what the best course of action is for that particular case.
Perfect. So thanks once again, and wish you all the best. I know you have upcoming trials coming up, so hope everything goes well there with you. And again, thanks again for joining us, and thanks everyone for tuning in. And hope we see you again tomorrow for we actually have interesting. You might know Sia Pashang there, I think, as well, and Adrian Nicolini. They're going to kind of look at litigation there from the civil and the criminal lens. So I think we can continue on with this tomorrow. And thanks again. Take care, everyone.
Thanks so much, Hussein. And thanks, JP. Have a great day.
No problem.